By to me. Reynolds versus Sim. Plaintiffs below allege that their last apportionment of the Alabama legislature was based on the 1900 federal census, despite the requirement of the state constitution that the legislature be reapportioned decennially. They asserted that since the population growth in the state from 1900 to 1960 had been uneven, Jefferson and other counties are now victim of serious discrimination with respect to the allocation of legislative representation. As a result of the failure of the legislature to reapportion itself, plaintiffs asserted they were denied equal suffrage in free and equal elections and the equal protection of the laws in violation of Alabama Constitution and the 14th Amendment to the federal Constitution. On July 21, 1962, the district court held that the inequality of the existing representation in the Alabama legislature violated the Equal Protection Clause of the 14th Amendment, a finding which the court noted had been generally conceded by the parties to the litigation. Since population growth and shifts had converted the 1901 scheme, as perpetuated some 60 years later, into the invidiously discriminatory plan, completely lacking in rationality. Okay, I hope that's what the district court said after hearing facts. It says the court noted, district court held that the inequality violated violation of the Equal Protection Clause. Why again? The holding was that generally conceded by the parties to the litigation since population growth shifts. Right. Okay, they're using old populations. Whatever. Under the existing provisions applying 1960 census figures, only 25.1% of the state's total population resided in districts represented by a majority of the members of the Senate, and only 25.7% lived in counties which could elect a majority of the members of the House of Representatives. Population variation ratios of up to about 41-1 existed in the Senate and up to 16-1 in the House. Bullock County, with a population of 13,462, and Henry County, with a population of only 15,286, were each allocated 2 seats in the Alabama House, whereas Mobile County, with a population of 314,000, was given only 3 seats, and Jefferson County, 634,000 people, had only 7 representatives. With respect to the senatorial apportionment, since the pertinent Alabama constitutional provisions had been consistently construed as prohibiting the giving of more than 1 Senate seat to any one county, Jefferson County, with over 600,000 people, was given only 1 senator, as was Lowndes County, with a 1960 population of only 15,000, and Wilcox County with only 18,000. So these are all pertinent facts. No effective political remedy to obtain relief against the alleged malapportionment of the Alabama legislature appears to have been available. No initiative procedure exists under Alabama law. Amendment of the state constitution can be achieved only after a proposal is adopted by 3/5 of the members of both houses of the legislature and is approved by a majority of the people, or as a result of a constitutional convention convened after approval by the people of a convention call initiated by a majority of both houses of the Alabama legislature. Undeniably, the Constitution of the United States protects the rights of all qualified citizens to vote, in state as well as in federal elections. A consistent line of decisions by this court in cases involving attempts to deny or restrict the right of suffrage has made this indelibly clear. It has been repeatedly recognized that all qualified voters have a constitutionally protected right to vote and to have their votes counted. Undoubtedly, the right of suffrage is a fundamental matter in a free and democratic society, especially since the right to exercise the franchise in a free and unimpaired manner is preservative of other basic civil political rights. Any alleged infringement of the rights of citizens to vote must be carefully and meticulously scrutinized. So this is the standard strict scrutiny. Okay, so this, I guess, is the rule. Undeniably, the Constitution protects the right to vote. Fundamental. Suffrage is a fundamental matter in a free and democratic society. So it's a fundamental right, protected by strict scrutiny. In so many words. Legislators represent people, not trees or acres. Legislators are elected by voters, not farms or cities or economic interests. As long as ours is a representative form of government and our legislators are those instruments of government elected directly by and directly representative of the people, the right to elect legislators is free and unimpaired fashion, is a bedrock of our political system. It could hardly be gainsaid that a constitutional claim had been asserted by an allegation that certain otherwise qualified voters had been entirely prohibited from voting for members in their state legislature, and if a state should provide that the votes of citizens is one part of the state that should be given 2 times or 5 times or 10 times the weight of votes of citizens in another part of the state, it could hardly be contended that the right to vote of those residing in the disfavored areas had not been effectively diluted. It would appear extraordinary to suggest that a state could be constitutionally permitted to enact a law providing that certain of the state's voters could vote 2, 5, or 10 times for their legislative representatives, while voters living elsewhere could only vote once, and it is inconceivable that a state law to that effect, in counting votes for legislators and votes of citizens in one part of the state, would be multiplied by 2, 5, or 10, while the votes of persons in another area would be counted only at face value, could be constitutionally sustainable. Of course, the effect of state legislative districting schemes, which give the same number of representatives to unequal numbers of constituents, is identical. So the effect is inconceivable. Overweighting and overvaluation of votes of those living here has a certain effect of dilution and undervaluation of the votes of those living there. The resulting discrimination against those individual voters living in disfavored areas is easily demonstrable mathematically. Their right to vote is simply not the same right to vote as that of those living in a favored part of the state. 2, 5, or 10 of them must vote before the effect of their voting is equivalent to that of the favored neighbor. Weighting the votes of citizens differently by any method or means, merely because of where they happen to reside, hardly seems justifiable. One must be ever aware that the Constitution forbids sophisticated as well as simple-minded modes of discrimination. State legislatures are, historically, the fountainhead of representative government in this country. A number of them have their roots in colonial times and substantially antedate the creation of our nation and the federal government. Full and effective participation by all citizens in state government requires, therefore, that each citizen have an equally effective voice in the election of members of his state legislature. Modern and viable state government needs, and the Constitution demands no less. With respect to the allocation of legislative representation, all voters, as citizens of a state, stand in the same relation regardless of where they live. Any suggested criteria for the differentiation of citizens are insufficient to justify any discrimination as to the weight of their votes, unless relevant to the permissible purposes of legislative apportionment. Since the achieving of fair and effective representation for all citizens is conceitedly the basic aim of legislative apportionment, we conclude that The Equal Protection Clause guarantees the opportunity for equal participation by all voters in the election of the state senate legislators. Diluting the weight of votes because of the place of residence impairs basic constitutional rights under the 14th Amendment, such as an invidious discrimination based upon factors such as race or economic status. Interesting that they can make that statement so plainly. We are advised that states can rationally consider factors other than population in apportioning legislative representation. We are admonished not to restrict the power of the states to impose differing views as to political philosophy on their citizens. We are cautioned about the dangers of entering into political thickets and mathematical quagmires. Our answer is this: a denial of constitutionally protected rights demands judicial protection. Our oath and office require no less of us. To the extent that a citizen's right to vote is debased, he is that much less a citizen. The fact that an individual lives here is not a legitimate reason for overweighing or diluting the efficacy of his vote. It's sad to say, but like, geography does affect, or does happen to have race and economic status or effects. The complexions of societies and civilizations change, often with amazing rapidity. A nation once primarily rural in character becomes predominantly urban. Representation schemes once fair and equitable become archaic and outdated, but the basic principle of representative government remains and must remain unchanged. So this is like kind of the need to modernize. The weight of the citizen's vote cannot be made to depend on where he lives. Population is, of necessity, a starting point for consideration and a controlling criterion for judgment in legislative apportionment controversies. A citizen, a qualified voter, is no more nor no less so because he lives in the city or on the farm. There is a clear and strong command of our Constitution's Equal Protection Clause. This is an essential part of the concept of a government of laws and not men. This is at the heart of Lincoln's vision of government of the people, by the people, and for the people. The Equal Protection Clause demands no less than substantially equal state legislative representation for all citizens of all places as well as all races. We hold that as a basic constitutional standard, the Equal Protection Clause requires that the seats in both houses of a bicameral state legislature must be apportioned on the population basis. Simply stated, the individual's rights to vote for state legislators is unconstitutionally impaired when its weight is in the substantial fashion diluted when compared with votes of citizens living in other parts of the state. Since neither of the houses of the Alabama legislature under any of the three plans considered by the district court was apportioned on a population basis, we would be justified in proceeding no further. However, one of the proposed plans that contained in the so-called 67 Senator Amendment at least superficially resembles the scheme of legislative representation followed in the federal Congress. Under this plan, each of Alabama's 67 counties is allotted one senator, and no counties are given more than one seat. Arguably, this is analogous to the allocation of 2 Senate seats in the federal Congress to each of the 50 states, regardless of population. The system of representation in the 2 houses of the federal Congress is one ingrained in our Constitution as part of the law of the land. It is one conceived out of compromise and concession indispensable to the establishment of our Federal Republic. Arising from unique historical circumstances, it is based on the consideration that in establishing our type of federalism, a group of formerly independent states bound themselves together under one national government. Admittedly, the original 13 states surrendered some of their sovereignty in agreeing to join together to form a more perfect union, but at the heart of our constitutional system remains the concept of separate and distinct governmental entities, which have delegated some, but not all, of their formerly held powers to a single national government. And some of the rules of election are in the Constitution, but some of them, but they're not, I don't think I certainly know that they're not to this degree of detail. Which might be discussed in the dissent. Political subdivisions of states, counties, cities, or whatever never were. So I'm just going to write constitutional process here. But knowing that it's thought about in the Constitution, but it's not expressed in this degree of detail. Never were and never have been considered as sovereign entities. Rather, they have been traditionally regarded as subordinate governmental instrumentalities created by the state to assist in carrying out the state governmental functions. Thus, we conclude that the plan contained in the 67 Senator Amendment for apportioning seats in the Alabama legislature cannot be sustained by recourse to the so-called federal analogy. By holding that as a federal constitutional requisite, both houses of a state legislature must be apportioned on a population basis, we mean that the Equal Protection Clause requires that the state make an honest and good faith effort to construct districts in both houses of legislature as nearly of equal population as is practicable. We realize that it is a practical impossibility to arrange legislative districts so that each one has an identical number of residents or citizens or voters. Mathematical exactness or precision is hardly a workable constitutional requirement. Okay, so this whole constitutional election process is actually part of this amendment trying to resemble what was set forth in the Constitution. Okay, that's what I didn't understand. Justice Harlan dissented. In these cases, the court holds that seats in the legislatures of 6 states are apportioned in ways that violate the federal Constitution. Under the court's ruling, it is bound to follow that the legislators in all but a few of the other 44 states will meet the same fate. These decisions have the effect of placing basic aspects of state political systems under the pervasive overlordship of the federal judiciary. I must register my protest. Because they're saying the states should have that right to be independent. Today's holding is that the Equal Protection Clause of the 14th Amendment requires every state to structure its legislatures so that all the members of each house represent substantially the same number of people. Other factors may be given play only to the extent that they do not significantly encroach on this basic population principle. Whatever may be thought of this holding as a piece of political ideology, and even on that score, the political history and practices of this country from its earliest beginnings leave wide room for debate. I think it demonstrable that the 14th Amendment does not impose this political tenet on the states or authorize this court to do so. So they're stretching, and they're infringing in political ideology. And whether it's right or wrong, it's true. Whether the reasons are right or wrong is true. That they're overstepping their powers that this court is meant to limit. Had the court paused to probe more deeply into the matter, it would have found that the Equal Protection Clause was never intended to inhibit the states in choosing any democratic method they please for their apportionment of their legislators. Right, it was never intended to do that. This is shown by the language of the 14th Amendment taken as a whole, by the understanding of those who proposed and ratified it, and by the political practices of the states at the time the amendment was adopted. It is confirmed by numerous state and congressional actions since the adoption of the 14th Amendment, and by the common understanding of the amendment is evidenced by subsequent constitutional amendments and decisions of this court before Baker and Carr made an abrupt break with the past in 1962. The failure of the court to consider any of these matters cannot be excused or explained by any concept of developing constitutionalism. It is meaningless to speak of constitutional development when both the language and history of the controlling provisions of the Constitution are wholly ignored. Since it can, I think, be shown beyond doubt that state legislative apportionments as such are wholly free of constitutional limitations, save such as may be imposed by the Republican form of government clause of the Constitution, Article 4, Section 4, the court's action now bringing them within the purview of the 14th Amendment amounts to nothing less than an exercise of the amending power by this court. So far as the federal Constitution is concerned, the complaints in these cases should all have been dismissed below for failure to state a cause of action, because that has been alleged or proved shows no violation of any constitutional right.